Hello, my name is Kelly Busch. I first became involved in the issues of water policy and international trade in 1999 when I was sent to Ottawa to attend the Council of Canadians Water Watch Summit. Since then, I have completed my thesis entitled Water and Social Activism in Canada, and I have continued to study issues of water and trade. I've been asked to speak about water policy and the Security and Prosperity Partnership. An April 13, 2007 press article stated, quote, "Canadian water is on the table at trilateral talks between politicians, business people, and academics from Canada, the US, and Mexico. Future 2025 project will include discussion of water transfers and diversions. The project was launched by the three governments in March 2006 to help guide the ongoing Security and Prosperity Partnership, a wide-ranging effort to further integrate the country's practices on everything from environmental rules to security protocols and border controls. A draft report will be submitted to the three heads of state at a partnership summit in Alberta this August," end quote. After the Alberta Summit in August, both the Government of Canada as well as senior American officials have been quick to say that water is not on the table. Minister John Baird issued a statement saying that the Canadian government, quote, "has no intention of entering into negotiations behind closed doors or otherwise regarding the issue of bulk water exports," end quote. Tom Huffager, the U.S. Consul General for Alberta, Saskatchewan, and the Northwest Territories, stated emphatically, quote, "We seek no bulk water transfers," end quote. He went on to say, quote, "Our policy has not changed at all, and we really just want to get that across to Canadians. We are hoping this story will go away," end quote. This is standard practice in terms of water and international trade policy negotiations between Canada and the US. Float the idea of trade in water, and when the public reacts negatively, damn the idea in public and rechannel it in private. The issue of bulk water exports and water diversions are where many Canadians draw the line against the practices of free trade. In the Free Trade Agreement, FTA, signed in 1988, Canadians were repeatedly assured that water was not to be a part of the trade agreement. Notwithstanding the statements of politicians that water was not a part of the FTA, the contents of Article 409 of the text of the agreement and subsequent legislative actions on the part of the Canadian government clearly indicate otherwise. Canadians were also told that water was not covered under the North American Free Trade Agreement, NAFTA, which again is not true. Water is covered by the Harmonized Tariff Schedule, and the schedule is a separate volume to the NAFTA. As a result of this fact, Canada has been sued for $10.5 billion US under the odious provisions of Chapter 11. I do not know what the outcome of the Sunbelt claim against the Canadian government has been. What I do know is once again the Canadian government has intentionally withheld the truth from the public. At one time, the Department of Foreign Affairs and International Trade website did disclose the notice of intent to submit a claim for arbitration filed in November of 1998. But to the best of my knowledge, it has never shown the notice of claim and demand for arbitration filed in November of 1999. Now, under Canada's new Conservative government, there is no reference to the documents on the old website and no link showing where the documentation may now be found. However, these documents can still be accessed on the Sunbelt website. Canadians need to ask why indeed this is the case. On February 13, 2001, the lawyer for Sunbelt, John Carton, filed an amicus curiae brief within the first domestic review of the NAFTA, which was heard in Vancouver by the Honourable Mr. Justice Tyso. The brief included the two submissions originally made to the NAFTA Tribunal and was brought to the court by way of affidavit. Using the two NAFTA submissions as primary reference materials, The affidavit addressed a Canadian company entitled Western Canada Water Enterprises Limited. It is alleged by Mr. Carton that this company was set up in 1989 by people close to the Socred government to establish a secret monopoly for the purposes of exporting bulk water. It really is a fascinating story that I'm sure many, if not all of you, have never heard. However, in a letter written by David H. Vickers to the then Minister of Environment, John Kishore, in November 1991, provides some independent validation of Carton's allegations. The letter in part reads as follows, quote, "I act for the Central Coast Power Corporation. My client is currently involved in litigation with the Crown. At the root of the problem is that friends of the former government, Western Canada Water Corporation, are taking water from behind my client's dam at Ocean Falls without any compensation to my client. I think the issue needs sound political judgment, tied as it is to the whole issue of water export." End quote. Nearly 15 years later, in response to a legal inquiry in December of 2005, the now Honorable Mr. Justice Vickers responded, quote, "I have no direct recollection of this matter, and I no longer have a file to which I can refer to refresh my memory." End quote. Clearly, then, there must be some substance to Carton's allegations. Otherwise, in my opinion, it is highly likely that Mr. Justice Vickers would simply deny or refute his earlier written statements. In any event, you may be wondering what the issue of Western Canada Water has to do with the current government policy on trade in water. Let me try to explain. I believe that this history has directly led to the amendments that have been made to the Boundary Waters Act. On December 10, 2002, the Government of Canada announced that amendments to the Boundary Waters Treaty Act and related regulations have come into force. The stated purposes included a, quote, "prohibition of bulk removal of boundary waters from Canadian basins for any purpose, including export," end quote. However, the stated purposes, unfortunately, do not necessarily match up with the practical effect. Senator Carney, along with Wendy Home, a longtime expert in water and trade policy, both assert that the Boundary Waters Act provides government with the ability to permit water removal by way of license. Senator Carney, in commentary recorded in Hansard, puts it this way, quote, "Bill C-6 as written could actually be used to permit some bulk water exports where no such permission now exists," end quote. Wendy Holmes further explains, quote, "The amendments to the Act do not ban bulk removals of water from drainage basins, but rather restrict removals to license withdrawals at the pleasure of the Minister of DFAT, Department of Foreign Affairs and International Trade," end quote. In essence, the Boundary Waters Act, Bill C-6, now makes trade in water possible under existing Canadian law. This position is well documented by virtually all of the experts who testified in Senate hearings on Bill C-6. However, the experts and their respective reservations were, nonetheless, ignored, and the bill was passed into law against the express wishes of the Conservative senators. So where does this leave the issue of water and trade policy? Frankly, we are in a position that is very similar to that of British Columbia in the mid-1980s and early 1990s, when the government authorized a legal trade in water. Once again, we have senior members of the government who can legally permit the export of water and can do so in virtual secrecy because they are protected by cabinet privilege. In spite of the fact that Senator Carney repeatedly tried to plug the holes in the Boundary Water Act, first in the Senate hearings on Bill C-6, and later by way of Bill S-225, an act to amend the International Boundary Waters Treaty Act, Senior members of this new Conservative government now have the ability to surreptitiously sell water for export. What's more, the current Minister of International Trade, David Emerson, was the Deputy Minister of Finance and then the Deputy Minister to the Premier within the BC government that first tried to sell water from Canada. Furthermore, the then Minister of Environment, John Reynolds, was the man responsible for licensing water in BC at the time, and is the same man who brought Mr. Emerson into the new Conservative government. All of this leads me to wonder if it's merely coincidence that the levels of the Great Lakes have measurably dropped in the past couple of years, irrespective of the fact that there has not been a marked change in the weather and the precipitation of the region. Therefore, in my humble opinion, the greatest threat in terms of bulk water exports comes not from the FTA, the NAFTA, or even the Security Prosperity Partnership. Instead, I believe the immediate threat to Canadian water is under the Boundary Water Act and those ministers and associated individuals who are entrusted with the stewardship of this international treaty. But then, what do I know? As an aside, I do know that Mr. Emerson was in and around a process that took decades, which eventually led to the sale of Terrason Water Services to Kinder Morgan. In fact, he was the Minister of Industry in the past Liberal government when the sale was ratified, but because of his extensive holdings in the company, chose instead to recuse himself from acting in his ministerial capacity. But that's another story.